good morning, everyone. As people join the room, I shall start the introductions and let you know what's going on. So this is the latest edition of ConstructionCast. We're going to have a chat today about construction dispute funding. So we've done this once before, I think, a few years ago. In fact, I know we have, because when we were preparing this, Khushboo and Andrew pointed out that they already knew each other because they'd been on the same topic during lockdown. So there we go. So we have talked about this before. Can't quite remember what we said, so it's worth having another look. And also we've got a new speaker joining us today, so that'll make a difference to the dynamic and the discussion anyway. So thank you to all three of you for joining us this morning. We've got Andrew Roberts, formerly, when he was last with us, he was at Augusta Ventures, but he's now moved to a firm called Omni Bridgeway. So Andrew is Senior Legal Counsel and an investment manager based at Omni Bridgeway's London office. Formerly, Andrew was a construction solicitor at various places, including Kia, which will be known to many of you, and also various major law firms such as Pinsent Masons and Aiken Gump, and I think it's Aiken Gump, Strauss and Howard, various law firms always like to add more names to their title. So that was Andrew's background. And we've got Sobiya Ameen, who is an international arbitration lawyer based in India. She's written on the subject of dispute funding quite extensively, which is how I came across her when I was Googling the subject to see who might be interested in talking about it. So she's based in Delhi, done lots of things, looking at her LinkedIn profile, including founding a food charity to help people out during lockdown, joint secretary of the World ADR Women, as well as a member of the LCIA and Asian International Arbitration Centre. So thank you to Sobiya for joining us. We've got Khushboo Shadhadpuri, who is from Tamimi, an old friend of ours and ConstructionCast and the Limeslade Masterclass. Khushboo will be familiar to lots of people on the call. One of the most well-known lawyers, I think, in the Middle East in construction. She's dual qualified in Singapore and New York. She's a partner at Tamimi and Company in Dubai. Also sits as an arbitrator and as a prolific writer and presenter, where many of you will have come across her at various arbitration weeks and dispute weeks and all the other things that we've met each other at in the past. So thank you to all of you for joining us this morning. So that's all of that. So we'll move on to construction dispute funding. So if we start with Andrew, funding of construction disputes litigation is not a new thing. Certainly, obviously, we've spoken about it before. But what's changed recently, and is it becoming more or less popular both here in the UK and around the globe, do you think? I've got to find the unmute button. Well, is there somewhere?
Sorry about that. Thanks, Stuart, for the introduction, and sorry everybody about that. Right, I thought I'd just probably start with a quick recap on where we've been in the last 5, 6, 7 years. It's probably about 5 years since we talked on this. And I think that was around the time that things were really starting to take off for funding in the construction sector. So I thought I'd just quickly recap on what made it popular to begin with, and then review whether those factors still apply, and then look at what's changed as well off the back of that. So just as a recap, I would say, I mean, funding has always made sense for the construction industry. It's a very litigious area. There are lots and lots of claims on most projects, whether they're in contract claims or ballooning into formal disputes. They're also very expensive claims, and that means they're a significant drain on capital and cash flow in what is a very low profit margin environment. So it makes a lot of sense. You've also got a lot of very commercially minded decision makers in construction businesses who can generally see the sense of using someone else's capital for some of the most risky investments that they're making within their business, i.e. litigation. So it'll make sense, and it's still popular for all those reasons. And in some cases, it is an essential tool for businesses to actually recover lost monies, who perhaps don't have that spare cash to put towards lawyers. On the other hand, there are some factors that are still holding back further growth, I think. There's on one hand, you've got the fact that construction businesses, as much as anyone, they don't really like having to give up a significant share of their proceeds of hard fought litigation. There are some good reasons for that. And a lot of it's to do with the nature of a construction claim. Often you are talking about recovering tangible incurred cost, monies that are rightfully yours, in your opinion, under a contract, or perhaps you're recovering the cost of remediation or something like that. A good example being all of the work that's being done to remediate buildings in the UK post Grenfell under the Building Safety Act. There's contractors out there doing the right thing, getting things fixed, and then pursuing the cost to compensate for that from other actors like their subcontractors and architects. It doesn't make much sense for them to do all that work and then only recover a portion of it because the rest of it's going to a funder. So there are factors at play like that in the construction industry that are quite unique. And then I think there's also that tradition within construction that businesses are used to leaving money aside to budget for litigation because they know it'll come at some point soon. They're used to paying for it. So it's not necessarily something that they feel the need to avoid. So for those reasons, it can be harder to get traction with some construction businesses. Then there's the fact that construction claims aren't always easy to fund. That it's a very high risk subject matter often, very detailed, very technical, and sometimes I'd say some of the best construction lawyers I work with are the most candid about the fact that it can be very hard to predict the outcome of a complex construction claim until you're very deep into the arbitration or litigation. So that makes it very difficult for a funder who's trying to make a prediction right at the beginning most of the time. And then it can be very hard to secure for that reason. We need to be sure that we're funding a good claim. And sometimes a lot of work needs to be done up front to package up a construction claim in a way that makes it clear that it is a good claim and that it's going to be valuable. And there's almost a catch-22. A claim will come to us, it's not developed well, and there are good reasons for that. It costs a lot of money just to package it up. And we're being asked to fund that work, essentially. And we're having to say, no, you need to find your own money to get it to a certain point, then we'll help. That's not very helpful. And so we're having to come up with solutions to that and try and meet people halfway. So that's one thing that's changing is trying to come up with a lot of different solutions and products that try and answer the question of how to fund more construction claims and fund them more easily. And other things that are changing in the regulatory sort of sphere, there's been a few changes over the recent years. A lot of people have heard of the Supreme Court decision in PACCAR in 2023 in the UK, which was quite a slight bombshell for the litigation funding industry here. Just very quickly to summarize, it decided that litigation funding agreements should be classed as damages-based agreements under relevant legislation, which are essentially agreements that are normally between a lawyer and a client. And it meant that most litigation funding agreements were finding it difficult to comply with legislation. And we needed to make some changes to how we were structuring a lot of our funding to address that. I think for the most part we've done that, and funding is still prevalent in the UK, and coming forward there will be a sort of a clarification of exactly what the law should be around that anyway. There's a Civil Justice Council review that's in its final stages at the moment, which might shed some light on that too. And then around the globe, you've got other regulatory changes. Hong Kong and Singapore are good news stories. They recently, or not so recently now, but in the last few years, legislated to enable funding for arbitration. And that's been really positive, and there's been good take up there. Some other jurisdictions that's been slightly less positive. A few years ago in Australia, they made some changes which suppressed a lot of the funding industry. That was reversed quite quickly. In the US, you've got a few states that are trying to clamp down on funding for various reasons, often driven by big business, and attempts to try and get funding agreements disclosed, which is quite a sensitive area. So you've got a bit of that sort of thing going on as well. But for the most part, the funding industry is still growing steadily. In terms of just recapping on the evolving sort of products that we've got, that we're sort of trying to develop to meet demand, going back to that dilemma about the cost of developing a claim versus the ability to actually get a funder to help, which we're introducing more types of what we call early stage funding or claims development funding, with a view to being able to actually put forward the capital up front to fund that exploratory analysis and bring claims up to a level where they might end up being at arbitration or litigation standard. And the whole idea behind that is to try and find a way that we can align with the client from the beginning, to say we can fund the sort of limited cost required to get the claim to a certain standard where we can all collectively assess what the true value or the fair value of the claim is, and then decide together what would be the best way to monetize that, whether it be by way of an amicable settlement strategy or going straight to an arbitration, and trying to commercially align ourselves in that way. That cuts down some of the risk for a funder in terms of putting out non-recourse capital on something that might ultimately not be good enough to go all the way through an arbitration process. We're also looking at trying to purchase claims a bit more. Some jurisdictions are quite amenable to that, and that's something that is perhaps more prevalent in a portfolio context where you're looking at an entire book of claim assets. We can cover that more later, perhaps. I've probably spoken for long enough. I should open the floor to others.
There's a lot to cover. So,
yeah.
Khushboo, I think you had something to add to that as well, did you? Is that right?
Well, just really quickly, maybe first just say hello to everyone, and also a couple of nuances from the Middle East to add on to Andrew's introduction of third-party funding, which is pretty comprehensive. I think in the region in the Middle East, because 60% of the GDP comes from family businesses, so a lot of the disputing parties have interrelated companies with multiple operations, and something we do see that's being perhaps utilized a bit more frequently is that these holding companies with multiple subsidiaries and sister companies have projects and operations across different sectors where they have a number of legal proceedings, and then they club all of these claims, and some of them are obviously for, some of them are against them, but they club it in one portfolio and then siphon that off to funders like Andrew and alternative companies. And so from the client's perspective, funding is then used more like a finance and risk management tools, but also to hedge their sort of a risk against each other, where they have a couple of good claims and a couple of claims that might not be as strong. And the same for the funding perspective, taking on this portfolio because it's a big client, it's an important client, and they're quite conscious of the fact that not all of these claims are going to be great claims, but they do it again for sometimes to maintain the relationship with these big corporations, and also because the returns from some of these claims are so huge that it still makes sense to take even the other claims that might not be as profitable or as strong. So I just wanted to add, this is something we see being used a little bit more in the Middle East now.
Brilliant, thank you. So Sobiya, what your article in particular that I read was sort of extolling the benefits and how dispute funding has helped your clients and people in your region. How firstly, regionally, how do things vary, but also what do you find to be the main benefits and also challenges for your clients when using funding to resolve a dispute?
Talking about like third-party funding or funding, particularly in construction dispute, it is quite prominent in India in terms of arbitration, not in litigation. So this is kind of a benefit for people who are dealing disputes through arbitration, but it becomes a challenge for people who are doing it through litigation because it's very hard for them to secure funding if the matter is in litigation. This is something that is very prominent in India. So it is seeing the growth. Third-party funding is still very, very new here, but it's still seeing growth, but only specifically in arbitration. Litigation is very, very far from that for now. talking about the thing that Khushboo just mentioned, and Robert also, that there is a preference for portfolios over single cases because it holds a huge claim and opportunity for having more investment, more return on investments by the funders. So this is something, yes, but this also brings a set of challenges for parties specifically, because nowadays funders are looking on opportunities. Not nowadays, it is general that they are looking over the cases as an opportunity to invest, and they majorly prefer portfolio cases rather than single cases. In India as well, this is a huge practice that they are preferring portfolio cases, but this become a problem for parties who are having single cases. It's very hard for them to secure the funding, and the chance to secure funding, it becomes very narrow and it becomes very strict then, because the rejection rate gets higher. So it becomes quite difficult in that terms. The benefit, I would say, is that people think that it's generally for people who have no money, parties who do not have money. But again, Andrew focus on that, that it is for people also that who are having money. They don't want to just fix their capital, or they don't want their capital to be stuck into a dispute only. They want their capital to be free from dispute so that they can put it somewhere else, or they can utilize it commercially in a well mannered way. So in that manner, it is available for both people with money and people with no money. But as again, it has become a business model, so it's very hard. The parties who are facing financial struggles, they again fall into the pitfall of that struggle, that it becomes hard for funders to rely over them because they are financially not in a secured position. So it kind of creates a stigma, I would say, in that manner. The benefit is that yes, it frees up claimants or parties capital so that it can be utilized. Also, because in many regions it is a non-recourse finance, so it shifts the risk to the funders balance sheet, I would say. So parties are free from the risk whether they will win or lose, and they are not afraid that the money would be at risk. The money for processing through the dispute resolution would be at risk. So the risk automatically shift to the funder side. This is one of the major benefits that parties, I would say, look forward to in terms of securing the funding. But because it is non-recourseable and it is non-recourse finance, it again opens a window of a challenge, because the chances of acceptance of funding, or securing a funding, it gets very strict. It gets very narrow because the standards are very high. The funders look for various parameters to be satisfied in order to release funding to the parties. So this is benefit and again a challenge altogether, but it's something that is really in practice these days.
Great, thank you very much. Just very quickly, if you don't mind me asking, the reason why it's more prominent in arbitration and litigation, is that because it's easier to have certainty of outcomes, or is it just not something that's done in litigation, or is it?
So in terms of India, I'll be talking about, because here it is very true that the judicial system and the judicial progress in terms of litigation, it's quite slow. It's very slow. So the funders or the parties resist to take their matter to litigation, because sometimes, many cases, it takes a decade, and sometimes even more than decades. So the timeline for the return is quite wide, and it does not feel to be quite of an investment for the funders.
Brilliant. Okay, that's very useful. Thank you. Okay, very quickly, Andrew, how is eligibility defined, and how much work is required on your side in assessing and vetting a dispute for funding?
Sure. Good segue, because Sobiya has identified one really important factor, which is duration. So we'll definitely touch on that. I try to boil it down to essentially two golden rules that you need to satisfy to get funding for any claim. First, it has to be a good case. Funders won't touch anything that doesn't have a good chance of winning and recovering a good amount of money. And that includes making sure that the respondent has assets to actually meet its liability in due course. So it's got to be a good claim. And secondly, it has to make sense for everyone. The deal needs to make commercial sense. So that means you need to have a sensible loan to value ratio between the amount we're putting in, the amount it's going to cost to run the dispute, and what's going to come back for everyone. So that's two basic factors. Then it gets a lot more nuanced as you drill into the detail, of course, because there are lots of things we need to consider in terms of what constitutes a good case. And that's, you know, when it comes to a construction dispute, which we're focusing on here, it's possibly even more complex. We need to know that there's a good technical case. We need to know how the quantum is quantified and whether it's properly substantiated and going to stand up to the scrutiny of an experienced tribunal. We need to know that there are witnesses to support the factual detail, and there can be a myriad legal questions that also need to be dealt with. So we need to see a very strong legal analysis. When it comes to enforcement, it's not just a question of whether the respondent has assets. It's also a question of jurisdiction, the jurisdiction where those assets might be, the jurisdiction of the seat of the arbitration, and whether that's a safe environment within which to enforce, etc., etc. So there's a lot of factors to weigh up. And then on the economic side, we need to really scrutinize the likely budget and probably add a fair bit on to the estimate that we're given, because things always end up costing more. And then we really need to weigh that up and stress test it against a realistic quantum, not the headline quantum, not what's written in the statement of claim, but what we really think will ultimately get awarded. And there needs to be some serious headroom there to enable a funder to get a reasonable return on what is a very risky investment, but also ensure that the claimant is going to walk away with most of the proceeds. So that's a really crucial element of what we do, is to make sure that everything is equitable before we go forward. So we get a term sheet out really early that sets out exactly what our pricing is going to be. We stick to that, and we make sure the claimant is happy before we go into that detailed due diligence process.
Okay, fascinating. So yeah, and it's interesting that you mentioned that you touched on experts there, because that's it's almost like we plan these questions to follow on from each other. In our preparation calls, Khushboo, you mentioned what considerations you need to give to the appointment of experts in preparing a claim. So I don't know if you want to add a little bit on about that sort of side of the process.
No, I definitely do. But maybe before that, I'd like to touch a little bit about the eligibility of funding, because I think that's an important component of what we do when we help clients obtain the approval from the funders like Andrew, the due deep process, as we call it. And especially in construction disputes, there are some typical provisions that create uncertainty and risks on the legal aspect. It's always the same provisions. It's namely pay when paid provisions and notice provisions. And some of these legal arguments are so fact-centric. And at that point, the clients themselves and neither have we done a very deep dive of what are the evidences and documents in their arsenal to see where the gaps are. And sometimes the clients just don't know the extent to which a witness statement can cover those gaps. So for instance, when it comes to pay when and if paid provisions, unlike common law and civil law, as some of you may know, the beauty of civil law is that there are arguments that can be made, perfectly good arguments either way, depending on which side you're on. And so for us to leverage off these arguments, we really need to know the facts properly. Even for delay notices, for example, it could be, and we have seen in some of our cases where we successfully argue that the 5-day notice period under the contract should only apply not objectively but subjectively when a contractor, for example, is subjectively aware of when the event will cause a delay, not when the delay event actually occurred. So there's a nuance there which is very useful for us to capitalize on, but we just don't know the facts. So it's sometimes difficult in the due deep stage for us to write these legal memos to get the the funding's approved. And it also, depending on the company, the funding company, who's sitting on these panels, whether they have the same experience that we have, it can become a back and forth process that can take months, and even years. We've seen that. So I thought this was something important, just to sort of, from the client's perspective, this is something we help clients with, and we try to make it as broad as possible to give us that leeway to get the funding approved. Now, at the back of that is experts are the most important aspect of any construction dispute. I think no one would deny that. And where funders are involved, or in the process of being involved, they sometimes do want to have a say on who's appointed, which is obviously very fair and very reasonable. But also, depending on their experience in the region, they might not have that sort of knowledge of the experts that the law firms have or the clients have. And this is, again, going back to the point I mentioned, where a lot of the disputing parties in this region are interrelated companies. So it could be a holding company has multiple arbitrations, and I wouldn't say they prefer a certain expert over the other, but they are more familiar with certain experts. So they have that comfort that they'd want to appoint that expert in particular. And that sometimes becomes, again, another sort of conversation with the funder. And in some funding agreement, we have seen certain criteria that the funders want to ensure have been met before they appoint the experts. And it could be sometimes the regional proximity where the experts are based. It could be experience in that particular discipline. And then, especially for technical matters, MEP, piping, where it's power plant disputes, we see this quite a lot. For delay and quantum, not so much, because I think the market is pretty, I'd say, saturated for delay and quantum experts, if I may. So there's a lot of options. But sometimes for the really technical matters, we do need to look for experts outside the regions. ONG in particular, we need to keep going to Texas because there's just not that many experts here in the region. Also, experience in cross-examination. There are sometimes excellent experts who just don't have that arbitration experience, and that can be a deal breaker for some of the funding companies. So this is a few of the criteria we've seen. But generally, in my experience, the funding agreements have loose criteria around the experts. So the funders are usually very conscious not to overstep the boundaries of taking too much control over the appointment of experts, over our instructions to the experts as the legal counsel, and as well as over the arbitration strategy. So I think we do see both ways, that the funder, the disputing party, and us as the law firm representatives, we work quite well in such disputes. I mean, the only, probably I'd say, area where it can get a little bit sensitive is potential settlements. And this is what Andrew alluded to earlier when he spoke about funding for claims development. Now, claims development funding is very different from an arbitration funding, because in this sense, the funder is putting in money just to see where it's a good avenue for them to sort of get a good piece of settlement sum and get out early. But for the clients, they would prefer to do this before the funders even get involved, because then there's a huge percentage of the settlement sum going to the funders. So this is sometimes where we see this the prolongation period for the funding. It gets delayed because of this potential settlement avenues. So something interesting just to note.
Good. Okay, that's really good. Thank you. Just while we're here, if anybody's got any questions, do pop them into the chat or the Q&A box. And then finally, I thought we'd have just a round the room discussion. What regional variations there are out there on these sorts of things. So how do things vary in different parts of the world? If we start with Sobiya in India, I mean, do you see anything particularly different in India compared to other jurisdictions and other regions in the way that disputes are funded and the way that funders, I think you touched on it already, obviously, but in the way that funders interact with that region at all, with your region?
It's to some level, Stuart, it's quite similar, but yes, to some extent it differs. As I previously mentioned, in terms of litigation, it differs a lot.
Yeah.
So in comparison to other countries, India do have a bit slower mechanism for dispute resolution in courts, which narrow down the approaches of funding, which narrow down the options for funding. So yeah, this is something. Apart from that, if I talk about the evaluation phase of a case, it also, I would say it is quite less expensive. It requires less monetary involvement. That is, pre-evaluation phase in a construction dispute that is to be done by the law firms, or the in-house counsels of the parties that they do. It requires less of that investment in comparison to the scenarios I've seen for Singapore and UAE specifically. uh, a huge part or huge expense is involved in the diligence aspect, where in India it's not that. It is required, obviously it is absolutely required, but not as much as expensive it is. So it reduces quite of a burden from the client, from the party who is there, who is looking forward to secure it. So it becomes relatively easier to secure a funding for small disputes, I would say. Yes, it becomes easy in that matter. So this is something majorly I have seen in terms of difference, I would say.
Just while we're with you, we've got a question that's come in. Somebody has asked what experience or what experiences have you particularly had of third-party funding? Has it arisen? I guess the question is, has it arisen very often on disputes that you've worked on in your region at all? Has it come up as a thing that's been used in disputes that you've handled?
Yes, yes. So I'll talk about the dispute where we were looking forward to secure a funding, but we couldn't, and the reason we couldn't. So we were having a very strong case. It was related. It was purely a dispute where the other party was kind of insolvent. They have not declared insolvency, but they were on the verge of it. So they were in the position that they couldn't pay it, and solely because of that reason we were not able to secure funding. Apart from that, we were having a very, very strong case. The default was from the other side. The delay in the progress was from the other side. Every major fault was from the other side, but because they were not in financial good position, we could not secure funding. So the matter is still in progress. Hopefully that we land something. But yes, this is something, and this brings me to my challenge that the position of other party also affects that. Andrew also focused on that point, that if whether what kind of financial position the other party holds, what kind of assets they're having, it also affects whether you will secure the funding or not. Doesn't matter how strong of a case you're having. So this is something really um, that impacts the funding and a challenge that parties faces despite having a strong case.
Oh, great. Thank you very much. And then Andrew and Khushboo, I don't know which one of you wants to go first, but how do things vary in the regions that you operate in terms of Singapore, the Middle East, and even, I don't know if either of you get heavily involved in Asia Pacific and places like that at all?
Shall I quickly
fight it out.
I guess I was going to make perhaps a fairly obvious point, maybe more so for me than others, but certainly in common law jurisdictions, funders do need to be a lot more careful about the sort of historic doctrines around Shamptian maintenance, and that does colour our approach. And we need to be very cautious that we aren't seen to be exercising too much control over the dispute, and we do need to make sure we're very hands-off, very, very third party, and I think that does guide our approach. There's perhaps not the same specific principle in some civil law jurisdictions, and particularly across the continent, we do find that there are different approaches that can be taken, and indeed it's more common, as I mentioned earlier, for claims to be assigned to a funder even or purchased outright. And that is something that's been quite popular in the construction industry in recent years in some continental jurisdictions. So that's one interesting distinction, I would say, is worth mentioning.
Khushboo, anything to add?
Well, I mean, I can add that compared to its counterparts, the Middle East is a fairly unregulated market. So, Singapore, for example, there is initial capital investment or minimum capital investment that all funding companies need to maintain. I think the same in Australia as well, if I'm not wrong. Could be the same in the UK. But the Middle East is a market that's fairly unregulated when it comes to funding, which means it's fair game for any funder sort of come in if they have the initial cash capital to invest in these arbitrations. But it's also a very buoyant market because the large number of investments governments are making here in the infrastructure and construction sector, which makes it very interesting, to say the least. The one maybe aspect that came out when we discussed this session was compliance with Sharia law, and that has come up quite a bit in terms of a theoretical debate. And I would say a decade ago there was this apprehension from funders to come in because there was a sense that third-party funding is against Islamic finance principles or Sharia law, and we haven't actually seen this play out in practice because a lot of the court judgments around arbitrations are getting to the point where it's pretty pro-arbitration, where a funder has been used. A court wouldn't necessarily strike it out on the basis that it's unequal or it's prohibited in Islamic financing, but it's a possibility, especially where it comes to Saudi courts, because it's still a terrain that's fairly new and nascent when it comes to their development of the laws, and they're still in the phase where they have just adopted a new civil law. And they're trying to sort of get to the point of UAE and the other more advanced GCC court system. But in theory, there could be an issue with Sharia law, because there is a principle under Sharia law where interest is prohibited, called riba, as is speculative investment, called gurar, which is a bit more probably relevant to third-party funding. But having said that, funding companies are quite smart, so there's ways where we could replicate Islamic financing structures. So either the funder would defer the payment structures, or agree on fixed returns with variable outcomes based on the success of the case, as opposed to just a percentage. That's the way to overcome these Sharia law principles, if it ever even gets played out. And something maybe to add on is that third-party funding is actually expressly mandated or is provided for in a number of arbitration rules in the region. So not just Dubai and Abu Dhabi, also in Saudi, in Bahrain. So all of this obviously show the mindset that the government is changing. It might not be an explicit or something that's prescribed in the legislation because they just can't, because of their own cultural nuances. But it's something that the courts are very aware of, that this is a commercial reality that's been happening. So I would think it would be very rare for a funding company or a successful arbitration award that has been funded to be struck down or set aside just because of the involvement of funders.
Great, thank you. So very quickly, a couple of questions in the chat, which I will try and get to very quickly. Andrew, I think this one's almost certainly for you. How are funders responding to the fallout from MasterCard Merrick settlement? Not one I'm familiar with. Is that
well, it's it was an unfortunate situation, and I think there's probably more than one side to the story. I think it's probably, just for everyone's benefit, is a situation where a settlement was reached between the claimant and the defendant, which didn't necessarily leave the funder with a very satisfactory share of the proceeds in the funder's eyes, after what was a very intense, a long drawn-out litigation, very expensive litigation. So it just highlights really the risk that you take on all sides, where a claim doesn't proceed quite as you would hope, and settlement might not be as high as everyone was expecting when you first entered into the funding agreement. But it's worth mentioning that's a competition appeals tribunal matter, and there are different ways that settlement is examined by the courts and dealt with by the parties in that jurisdiction as well. So from my point of view, it doesn't really change much. The important thing is that when you do your due diligence and you get into an agreement with a claimant, you're all on the same page about what settlement might look like, and can continue to communicate throughout the course of the dispute on how best to approach that part of the equation. That's probably all I'd say on that.
Great. And then finally, who normally approaches the other funders, I think this is, and the funded, so the question is it the funded party, is it council, and what would attract the funded party to choose one funder amongst others, I guess? Is that who's, I mean, that could be any of you could answer that question, I guess. It's just depending on...
I'm happy to take that on from a private practitioner's perspective. The lawyer's perspective is usually we would give the list of funding company options to the client, or they could have some options that they are aware of themselves, but typically we would give it to them, and they would reach out, get some initial quotations. percentages, and then we would have like a joint discussion, get the funding agreement. But before the funding agreement, there's a due diligence process of the funders actually even agreeing or getting the approval to fund that claims, and that can take years. It can take months. It can take years. It really depends on the complexity of the claims, and I'll let Andrew speak about that. But just from our perspective, it's once the panel has approved the claim, then it moves fairly quickly. The funding agreement process, getting the terms negotiated and signed, can take weeks. And I'd say the most longer case we've seen is maybe 3 to 4 months, but it can also take weeks. We've seen it even done in days. The process of getting the funding approved, the one just before you get the agreement, that's the longest, because that can take back and forth between the panel, the funded party, and the council for years even. They might have certain queries, they might have, even follow-ups that require us to do a lot more research, a lot more memos to help the client to get the funding approved. But in the sense, what makes a funded or a funder attractive among the list is the returns. Really, it's the most important. How much returns will the client get ultimately from the claim, and how much percentage will be taken off to the funded party? I mean, that's probably the most important consideration. And then also the control that the funder would like over the whole arbitration or litigation process.
Yeah, I would say, ultimately probably the single most important factor for claimants tends to be the price. But it's very closely followed by confidence in the funder. I think it's quite important. And I think a lot of the time when we're selected, the feedback I receive is not just that we were perhaps the most competitive on price, but that we were able to demonstrate a clear understanding of the substance of the dispute. And I think it's particularly important in construction, particularly because you don't want to go down a 4 or 5 month process with a funder like Khushboo's describing, with someone who doesn't really understand what you're trying to tell them. And ultimately, if they don't understand it, they're not going to be able to sell it correctly to their investment committee and get the thing done. So I think particularly in niche areas like construction, it does pay to find people who understand the subject matter. It's probably a good factor to think about.
Okay, that's really useful. Thank you very much indeed. So I think that'll do for today. I've run over my usual official allocated time a little bit, but I thought there was lots of useful stuff in there. So thank you very much indeed. Thanks to all our speakers, Sobiya, Khushboo and Andrew. The next session, Annie will certainly organise. I can't remember what it's about, but we do have a plan. So we look forward to seeing everyone in due course. And yeah, thank you everyone for joining us this morning. It'll be on YouTube very shortly, and yeah, join us again next month. Thank you.